efficiency of judicial services. These initiatives are designed to bring justice closer to the people, making it more inclusive and equitable. In the past, outdated facilities and inefficiencies plagued
Dear delegates, can you take your seats, please? My Lord Chief Justice, we are ready to start the second session, whose focus will be judicial-led reform in East Africa as a recipe for the court efficiency and economic growth on criminal justice. So this is the second session that we are going to start. May I kindly invite the moderator of this session to come forward. And the moderator of this session is Lady Justice Olive Kazarwe Mukwaya. She's a judge of the High Court of Uganda. She has 25 years of legal expertise. She joined the bench in 2000 as a magistrate. She rose in the rank and she held various positions within the judiciary, both judicial as well as administrative. She's a holder of master's degree in international business law from Uganda Christian University. May I beg your attention, please? Dear delegates, she's also a holder of postgraduate diploma in public administration and management from Uganda Management Institutes, a postgraduate diploma in legal practice from Law Development Center, and a Bachelor of Laws from Makerere University. In May 2024, Honorable Justice Olive Mukwaya became the first female president of the Uganda Judicial Officers Association, UJOA, the first female ever since the association started in 1970. She's also the vice president of the National Association of Women Judges in Uganda, the Uganda chapter. Madam Justice, may I kindly welcome you to take the floor. You'll invite the presenter and also the discussants. Thank you.
Thank you, my Lord. My Lords, the Chief Justices, fellow delegates, participants in this conference, you're welcome to the second session. May I invite Chief Justice Othman to come and take his seat. He's the keynote speaker for this session. You're welcome, my Lord. May I invite Honorable Viola S. Mithoni from Kenya. Come and take your seat. From Uganda, we have the Honorable Justice Tadewa Simwe. You're welcome, my Lord. Rwanda, we have Honorable Justice Ruth Mukakalisa. Welcome, my Lord. Last but not least, certainly our host, Tanzania, we have Honorable Aisha Sinda, Judge of the High Court. Welcome, my Lord. As she comes, this session is titled Judiciary-Led Reforms in East Africa as a recipe for court efficiency and economic growth. Recently in Uganda, we had the unfortunate incident of having some of our leaders in the capital city arrested and charged for various offenses, which began their journey in the criminal justice system in Uganda. These are leaders who had held positions of authority and influence for at least 4 years, and then they find themselves caught in the criminal justice systems. Leaders like you and me. It therefore becomes relevant for us to have a session like this one, where the efficiency of courts is at the center, improving that efficiency, because when you're caught up in the justice system, the stress and emotional turmoil that you have to endure demands that you want it to be swift and to end quickly, preferably in your favor. God forbid that any of us gets caught up in the justice system. But let's hear from our first presenter, and I will introduce him. The Honorable Justice Mohammed Chande Othman served as Chief Justice of Tanzania from December 2010 to January 2017. During that tenure, he was also chairperson of the Judicial Service Commission. He is currently Chancellor of Adi University. In 2023 to 2024, Justice Othman served as chairperson of the Presidential Commission on the Reform of the Criminal Justice Institutions. Since 2017, Justice Othman has served as eminent person appointed by the UN Secretary General, charged with investigating the tragic death of the second UN Secretary General, Dag Hammarskjöld, and others. Justice Othman is also currently senior advisor to the prosecutor of the International Criminal Court. He is also chairperson of the UN Human Rights Council's International Independent Fact-Finding Mission for Sudan. My Lord Chief Justice, you're welcome to make your presentation.
Thank you very much. Honorable Chief Justice Juma, Chief Justice Hamisi Ramadhani, the President of our association, judges, principal judges, justices, registrars, magistrates, distinguished guests, good morning or almost good afternoon. Thank you for the invitation, and what I have been tasked to do is to share with you a number of perspectives concerning enhancing judicial foundation as cornerstone of the criminal justice chain. So what I wanted to do in the time allocated, and I know we are running out of time, so I wanted in the time that we have to share with you maybe 8 domains, and to pause to interrogate ourselves as we go along, to give an opportunity for the discussants to contribute. So by way of introduction, I think we all agree that jurisdictions in East have embarked on transitional frameworks, blueprints, or strategic agendas, by whatever name. And we share common goals, but with very specific particulars which are relevant to each country's context and situation. So it was said this morning here in Tanzania, you have 2 strategic plans and judiciary modernization program going on. Our colleagues in Kenya, they've had judicial transformation frameworks since the time of Chief Justice Mutunga, continued by Chief Justice Maraga, and now with social transformation through access to justice led by Chief Justice Koome. Uganda also the same strategic plan, and the same thing with Rwanda also having strategic plans. So all our region, we have strategic plans, we have blueprints. The second aspect of my introduction is that criminal justice, which is what we are centering, it has certain aims, and these are protecting society, the maintenance of public order, proper administration of justice, including victims of crime, upholding the rule of law, good governance, and everything that contributes to economic growth and stability and tranquility. The purposes of criminal justice, so they are tied to economic development, rule of law, and so on. But what I want us to pay attention is this. The dominant view, when one talks about criminal justice systems, is that it is a network of distinct but multiple interrelated public enforcement agencies, in particular the police, the prosecution, the courts, and the prison and correctional services. This is the primary view, the dominant view. And if you look also, the definition of substantive law also follows that. That is the process through which the government can detect, apprehend, convict, prosecute, convict, and impose punishment upon those who have violated the prohibitions of substantive criminal law. However, in reality, and I think this is important for us in the judiciary, and we should, criminal justice in all its facets is much broader. It involves significant non-law enforcement agencies or agents and institutions. So you can argue the legislature is part of criminal justice because it legislates criminal law. There are other non-prosecution components: forensic science, community services, legal aid organization, the bar, human rights association, victim association in Rwanda, very powerful, Abuga, survivors and witnesses organization. They are part of the system. But normally when we take a dominant view, we leave these out. And therefore the chain, we talk about the criminal justice chain, is somehow weak or broken. Another goal of criminal justice, we should remember, this touches us at the center of what we want to talk about today, is that one of the aims of criminal justice is also to protect the innocent from false, erroneous, or unsafe convictions, but to ensuring also that the guilty are not granted erroneous acquittals. And that is our central role as leaders of the judicial chain. And I think you know the famous saying by Goldstone, it is better that 10 guilty persons escape than one innocent suffer. That was said in the 1760s. But also in criminal justice, and we should look when we are here today, is that it has different stages: investigation, prosecution, adjudication, conviction, sentencing, incarceration, rehabilitation, reintegration into society. How does different stakeholders in the justice system deal with this, and how we, the court, as the cornerstone, are approaching these issues in relation to or with other colleagues. So that was my first point. The second one, what I would say is, what is the status of criminal justice in East Africa? So we can measure ourselves, but we are also measured externally. And for once, I just want to take, I don't always agree with the external indexes. There are many indexes of good governance, rule of law, and so on. But I just take one, and I think let's be objective and see what others say about us, instead of we looking at ourselves. I know all our judiciary, we have our own performance reports. So this is from the World Justice Project Rule of Law Index 2023. So criminal justice is measured. There is a factor 8, and this center on the courts, judiciary, and the central criminal justice chain. And they have 7 subsectors: effectiveness of criminal investigation, timely criminal adjudication, effective correctional services, impartiality of key judicial components, corruption-free criminal justice, criminal system is free from government influence, and respect of due process rights and the rights of accused persons. So you see, those sectors involve the judiciary, but they are tied up also with other members of the judiciary chain in terms of the ranking. 2023 in East Africa, those who are here, Rwanda ranked 41 out of 142, Kenya 87 out of 142, Tanzania 96 out of 142, Uganda 115 out of 142, and DRC 129 out of 142. They may be right, they may be wrong. The message is, we are performing, but we need to perform better, and we can perform better. In what way? Let us see together in the coming. When we look at the performances of the judiciary, let us also discuss the performances of the other sectors. So the third thing I wanted to share with you is the experiences in the Tanzanian Comprehensive Judicial Review, Criminal Review, 2023-24. There were many, many findings, but I just take out a few findings. And I think when you make the diagnosis, I think they will mirror other countries in East Africa. Tanzania, like many countries in the Commonwealth, did not have a national crime prevention and detection policy. No other country in East Africa has that, or in Africa. India is drafting one. Law enforcement agencies were more focused on criminal investigation and arrest, and not significantly on crime detection and prevention. Criminal justice agencies consisted of a web of over 40 institutions. So you see, we had a dominant view, only 5. There are in Tanzania more than 40 or 45 who are involved. To what extent, when we talk about stakeholder engagement, we are linking with the other? What relationship do our judiciaries have with the parole board, with the insurance companies? They are involved in traffic offenses, in compensating victims of crime for those motorists who are convicted by the court, and so on. Another one is multiple agencies and public officials in Tanzania have been granted powers of arrest, which were at times abused. And many agencies, apart from the police, were under law entitled to have places of custody. So not only police station, many other places of custody in which the police themselves sometimes did not know. including arrest powers. Many people have the arrest powers. Multiple institutions had overlapping mandates, engaged in criminal investigations. Criminal investigations were lengthy. There were forced confessions, occurrence, and I think we know this very well, for judges who try murder cases and you have to go through trial within a trial. So the burden is on the court, but who does the forced confession is another institution. How do we make judiciary efficient that way? Excessive force, bail denied, including for bailable offenses, and an astronomical rise in mandatory non-bailable offenses, resulting in pre-trial custody prolonged and violations of the rights of accused. When we had independence in Tanzania, we had 3 crimes that were mandatory non-bailable: treason, misprision of treason, and murder. We have now over 51 and more non-bailable offenses. 23 pieces of legislation needed amendment or reenactment. Plea bargaining process, which began in 2019, had made challenges, but it has, of course, improved challenges of transparency and so on. Prison overcrowding was chronic. Non-use of non-custodial sentencing. The criminal justice institution operated a multiplicity of information and management system, and they were not really sufficiently ICT networked, and they were thinly resourced, but also a mindset change was the most essential requirement in criminal justice transformation. So we came out with 333 recommendations implemented, including the judiciary is also a key player. In fact, the Chief Justice last year promulgated the criminal procedure, audio and video recording of interviews with suspect rules, because, as I say, major complaint about interrogation by the police in custody, which again burdens the court in terms of justice delivery. Now, zooming in on the cornerstone of criminal justice and the courts, I think there are 5 things, 6 things I think that I want to propose to you. And one is our role as courts and our constitutional duty. So we are the guardian of the Constitution. We have powers of final interpretation over the Constitution. We are mandated to protect and enforce fundamental human rights. And they are key: right to a fair trial, legal representation, right to be proven innocent, right to legal aid, and so on. And the question for us is, to what extent are we interpreting the Constitution in a manner favorable to fundamental rights in criminal justice? Okay. Over the last 5 years, let us take, what key decisions have we rendered protecting fundamental rights of significance, most significance to development of criminal justice in our jurisdictions? So that's a question that I pose on the first. The second one is on criminal law, criminal procedure, and evidential reform, and the role of the courts and the criminal justice chain. So here, there are a number of issues that arise. One is the reform in substantive criminal law. What have been our initiatives in reforming substantive criminal law? Or are we aloof and waiting the legislature and the government to move into that domain? But the second aspect of criminal procedure is procedural technicalities. All our Constitution, Article 159, Sub-Article 2D, the Constitution of Kenya, Article 107A, Subsection 2D, Constitution of Tanzania, Article 126, Subsection 3 of the Constitution of Uganda, say almost the same thing as a principle, that the courts have to administer justice without due regard or being tied up with procedural technicalities which may obstruct dispensation of justice. So irregularities is key. Who occasions those irregularities? The judiciary or stakeholders in the chain of criminal justice? And irregularity, procedural irregularities, you know, in criminal law, there's a distinction also with civil law, because in criminal law, they may vitiate proceedings. And where conflict exists between protecting the innocent and other objectives of a criminal justice system, protection of the innocent almost always prevails. And irregularities occasioning miscarriage of justice or prejudice or unfairness to an accused may warrant quashing of the conviction and so on. So as I said, who among the stakeholders is occasioning these procedural irregularities, and to what extent are they a burden to us, judicial officers, in dispensing justice? Another issue is in relation to evidential reform. Our Evidence Act, Tanzania, Uganda, in fact, surprisingly, the evidence that Uganda is kept 6, and Tanzania is also kept 6. So there's no competition there. Okay. All of them originate from India, from the Indian Evidence Act of 1872. Okay. So why do we have a law which is over 100 years old, and we all know, we practice it, and we know how difficult, how outdated it is? Okay? What is a fact? What's a fact in issue? What is this and that? Admissible, non-admissible, and so on. And in criminal justice, one of the issues we found out in the criminal justice system is about exhibits. We found that the police in Tanzania had almost over 11,000 exhibits in police stations all over the country. Okay? So these were the system of management. There is no information system between the police, the prosecution, and the court. Because some of those exhibits which have been entered in court to be destroyed, you need a court order. Okay, the initiative must come from whom? Not from the court, from the prosecution. Okay, and so forth. So there's a new system for exhibit management. But in fact, when you talk of evidence, even in the International Criminal Court, they have moved away, because there's a lot of litigation around the admission of exhibits in court. A lot of litigation. So the ICC has moved away from admission to submission. Submission of evidence, they moved away from admission of evidence to submission of evidence. You submit and let the court do the triage, assess the validity, the reliability, the credibility of evidence. They've moved away from admission. So I'm saying this evidential reform. The other aspect that I want to say is about adjudication, which is really, for us, one of the most central, and this is about case backlog and case backlog and caseload, and how we are managing that. Of course, there is a drastic improvement in the question of backlogs, but still it is a perennial issue that need to be discussed. I know judges have workloads, very heavy workloads, but I think in education there are many issues that we can discuss here, and I want the discussants maybe to share experiences. Delays in criminal investigation and how they're affecting the courts, how charging and prosecutorial policy influence decisions, the question of plea bargaining, the question of trial and appellate jurisdiction, the question of use of forensic sciences, especially in gender-based crimes. To what extent is DNA being used systematically for all gender-based crimes, in particular rape, gang rape, some of those offenses? And then compensation to victims of crimes. I think in most of our laws, victims of crime are shortchanged in terms of compensation or reparation for the harm that has been done to them. Another issue in adjudication I want to raise about miscarriage of justice, and this occur, of course, do not occur in a social legal vacuum. The police, the prosecution, forensic experts, it has been documented, have contributed to wrongful conviction. But what I found out in looking at miscarriage of justice is the data or the performance or annual reports of the Rwanda. Maybe our colleagues in Rwanda can help us here, because one of the measurements they use is the rate of overturned convictions. I think other countries, we don't do that. Okay, what is the experiences in measuring overturned convictions? Okay, I know judges sometimes when they're overturned, they're embarrassed, but I think it's a learning process, because maybe it's a higher panel and so on. I think let me reach out to two other things before I make concluding remarks, given the time allocated. And the other is about corrections and sentencing reform. That it is the court that renders sentencing, but sentencing cannot adequately be treated in a relative sense limited only to the challenges confronted by the sentencing judicial officers. So that the issue, sentencing also is one subject in which involves interrelationship between the different components of the criminal justice chain: the prosecution, the court, the prison correctional services, community services, but also the executive, the legislature, and the judicial branch of government have direct interest in sentencing policy and sentencing laws. So sentencing is an issue, and one of the issues in sentencing is about mandatory sentences, okay, and the elimination of judicial discretion in sentencing. The other issue also in sentencing is about the use or non-use by our judicial officers of community services order. If you look at the panorama in East Africa, we have varying degrees. I think Kenya uses it the most than other countries in the region. Okay, but this non-custodial sentencing as a way of reducing prison overcrowding. Okay, the chairman of the Uganda Human Rights Commission was saying the other day, in Uganda, prison overcrowding is out of control. Chairman of the, is not my saying, of the Uganda Human Rights Commission. Justice Maraga, when he did a review of the institutions in Kenya, said it is perennial. And there is data there in the report of the Maraga Task Force. So to what extent are we in the judiciary taking into account prison overcrowding when we are dispensing sentencing? Is it a factor or not a factor? Because it affects another institution in the justice chain. Okay, last year in the UK, the Secretary of Justice even advised the courts to stop sentencing because there were only around 300 spaces left in prisons in the UK. They had almost 88,000 inmates. Yeah, and then the ultimate issue that I raise is about the courts and stakeholder engagement. So I think the saying goes, a chain is as strong as its weakest link. Stakeholder engagement, I think it's very good in your strategic plans and so on, is a component of your transformation framework, of your strategy. Stakeholder engagement, I think we talk the same language in terms of who to reach out, but I think it's important to reach out, as I say, not those key institutions, but there are others also that may influence our work. And Tanzania, I think, judiciary took the lead in the integrated justice centers also, where you have other operators of the system in the same venue, the prosecution, community services, juvenile issue dealing with juveniles and so on. And so there are cross-cutting issues that I think we in the justice chain institutions need to look at together, about witness protection, as I said, the management of exhibits, legal representation and legal aid to the indigent, and so on. And again, another key player is the bar associations. And this bench bar, close cooperation, to what extent is it effective in our jurisdictions, really helping us to render criminal justice. So in conclusion, I think when you look at criminal justice, the role of the judiciary, the court, and the stakeholders, there are, I think, 4 issues that I would like to suggest. One is really that we need to be always conscious that there is a need to increase and to multiply public trust and confidence in the criminal justice system and its institutions. And I think I'm glad our judiciaries undertake nowadays the surveys, opinion polls or the surveys, in trying to know the public to what extent they have confidence in the judiciary. We found out in the criminal justice review some of the institutions very low public trust. I think if we want to continue to be the cornerstone of criminal justice, our transformative agendas and blueprints, we need to continue to take strategic leadership. And for me, strategic leadership is not only with the Chief Justice. Strategic leadership and the commitment and the will must be for all judicial officers at whatever level. Okay, so I think you as members of EAMJA should take the lead vis-a-vis your colleagues in providing strategic leadership also. It's an added burden, added responsibility as EAMJA members to continue to have this multiplier effect. The third proposition I want to make is the criminal justice chain. It needs to be a coalition of the willing. You need to have in these institutions a critical mass of champions who are ready to transform their own institutions, including to seek close cooperation and linkages with other stakeholders. So we can be running 100 kilometers an hour, but if the police is far behind, okay, they are not reforming, it will affect our performance. it will reject our judicial strength, our delivery. To the extent possible, give them a hand. Of course, it is their responsibility, but we can give them a hand. We can suggest, and I know in your decisions sometimes, people ask, is not your job, is it your job? To tell in a case, you say, well, this case has been poorly investigated. I've read it in judgments. Okay? This case has been poorly investigated. It means, you look, the judge is very furious. Yeah? Yeah, because, I mean, come on, you're wasting my time. Yeah? We had a case once, I was in the court once in a case. One of the assistant commissioner of police, he signed a search warrant. He did not call any other third party to witness the search warrant. And the GPO says clearly you must find a third person uninterested to sign the search. Of course, the court rejected that warrant, the search warrant. And then I think finally, is this a requirement for mindset changes in members of all the judicial chain, including the court, but also sometimes the public. Okay, mindset change in the public also, because you know the public not many times also want stiff sentences for minor crimes. Okay, so I wanted to share that, but my idea was also to raise some issue and to give a chance also to discuss and to give us latest in terms of development in their own jurisdiction, so that we can make this a lesson learned exercise. I thank you very much.
Thank you, my Lord Chief Justice. Another round of applause. Just to remind ourselves, he was working on enhancing judicial foundations, courts as a cornerstone of the criminal justice chain. Those are big words. And he has given us a lot to think about. Thank you, my Lord Chief Justice. We were told earlier that this engagement here at the EAMJA conference provides an opportunity for continuous learning and engagements, meaning the problems are systemic, and therefore the solutions must be timely and appropriate for the season. And they must come from us. So let's hear from Kenya. Our first discussant is the Honorable Viola S. Muthoni. Just give me a second. Viola S. Muthoni is a resident magistrate and lead adjudicator of the Small Claims Court, Mombasa, Kenya. Having been admitted to the Kenyan bar in the year 2011, she has over 12 years of work experience as a litigator in civil and criminal law. Viola served as a prosecution counsel at the Director of Public Prosecutions, Kenya, for 7 years before joining the judiciary of Kenya in November 2021. At her current role, Viola works together with 2 other adjudicators to determine small claims within 60 days from the date of filing. She supervises the staff of 6 of the Mombasa Small Claims Court Registry, chairs staff meetings, and signs the Performance Measurement and Management Unit, a monitoring and evaluation tool against which courts are measured in Kenya against set targets on behalf of the Small Claims Court Mombasa. Viola holds an LLB degree, honors from Kampala International University, Uganda, a postgraduate diploma in law from the Kenya School of Law, and an LLM cum laude in transnational crime and crime prevention from the University of the Western Cape, South Africa. Viola enjoys making new friends and hearing their life stories. Honorable Viola, you're welcome to make your presentation. A round of applause.
Honorable judges, honorable CJs, colleagues, ladies and gentlemen, good afternoon. It is my utmost and humbling pleasure to respond to some of the issues that have been raised by the Honorable ex-CJ of Tanzania. So mine is to share the Kenyan experience, and I will address the issue of the extent to which the courts in Kenya have interpreted the Constitution in matters of criminal justice. So I'll begin by stating that our Constitution has been lauded as one of the most progressive, given the provisions it has in the Bill of Rights. And the Kenyan courts have been at the forefront of protecting human rights, especially for the vulnerable. So in the criminal system, usually the accused person is vulnerable as they are pitted against a very well-resourced state prosecutor. So as the Honorable Moderator, Honorable Olive has said, even if it is one of us who finds ourselves on the other side of the dock, still, as compared to the prosecutor, you are still vulnerable. So then, the courts in Kenya have advanced interpretation of the Constitution in a purposeful way to protect the rights of the accused. I will give an example of the cases. In the case of Francis Kariuko Muratetu, the Honorable XJ has spoken about the mandatory death sentences. So in this case, the mandatory death sentence for murder cases was declared unconstitutional. So there was a follow-up advisory by the Supreme Court clarifying that this only applied to murder cases, but there's a leeway for the accused persons to petition for the same to be other offenses. So the courts have also of the mentally ill in conflict with the law and declared some sections of the penal code unconstitutional for how they deal with mentally ill persons. When it comes to the rights of victims, the High Court in Kenya has expanded the meaning of a victim to include companies and other juridical persons in criminal cases. So the court by 4 judges of the High Court, one is seated here with us, in the case of Coalition for Reform and Democracy and 2 others versus Republic is thriving in Kenya, and the courts shall stand strong, fearless in the exposition of the law, bold in interpreting the Constitution, in upholding the judicial oath. So other key cases include a case that involved a petition for a habeas corpus petition. I apologize. So in the case of the Law Society of Kenya versus the IG, this was an application for 3 persons who had been disappeared during the protests against the finance bill. And in this landmark decision, the Inspector General was held in contempt for failing to appear in court to explain where these people were. Interestingly, he failed to appear, and on the day when he was to purge the contempt, the 3 gentlemen reappeared. So this just to say, of course, the court's impact can be felt. On the right to fair trial, there has been several cases, including the case of Massimo Gore versus Republic, where the court held that the appellant's right to a fair hearing was infringed by the failure of the magistrate to comply with Section 200. This is the one that allows the accused person to apply for a rehearing of the case where the magistrate has been transferred. So there has also been cases on the right to bail and bond, including anticipatory bail. Also, there are cases on contravention of human rights, where state officers can be held personally liable where they contravene the rights of an arrested or accused person. So we also have a case on the prisoner's right to vote. So prisoners in Kenya are allowed to vote as long as they have not committed an election offense. So I would say that the Kenyan courts have played a transformative role in enforcing fundamental rights and freedoms for accused persons, suspects, and the public. There has been some laws that have been declared unconstitutional for being in contravention of the Constitution. That includes sections of the Penal Code, which I will not go through because of time. Criminal Procedure Code, Prisons Act, Victim Protection Act. So to highlight, on the Victim Protection Act, the courts have allowed victims to participate in the trial, but where the rights of the victim are in conflict with that of the accused person, then those of the accused persons prevail. So, we also have the National Police Service Act, Computer Misuse and Cybercrime Act. So the role that the judiciary has played, in summary, the one I've stated of declaring some provisions unconstitutional, issuing judicial directives, promoting jurisprudence, applying substantive justice as opposed to procedural technicalities, stakeholder engagement, acting as visiting justices to prisons, applying policies, including the bail and bond policy, sentencing policy, active case management guidelines, use of IT to enhance access to justice, and also this one I can say is the issue of conservation. As the Kenya judiciary, we have moved 100% online, and the goal is to go 100% paperless. So I will also comment on the issue of substantive justice versus procedural technicalities. So Article 159(2)(d) of our Constitution says that justice shall be administered without undue regard to procedural technicalities. We have seen our courts implementing this. On the legal and policy reforms, the judiciary has put in place the policies that I have mentioned. There is also the promotion of plea bargaining and diversion. So for diversion, maybe a point to note is that for children, they are considered automatically for diversion before they can be charged. So there are also institutional reforms, including performance management, promotion of alternative dispute resolution, training and capacity building, adoption of technology in trial. So some of the challenges and have been alluded to by the XCJ include resistance to change, resource constraints, and limited awareness. So for our stakeholders, there are some also challenges that we experience, including failure of them to avail police files, poor drafting of charge sheets, some of which have led to acquittals of accused persons. So for the ODPP, Office of the Director of Public Prosecutions, there are also challenges, but with stakeholder engagement, we can all surmount those challenges. So for the stakeholders, the police, the ODPP, there's also correction services and other supporting institutions, including the Children's Department, probation and aftercare, witness protection agencies, civil society organizations, of which there must be proper coordination for us to ensure that the goals are met. So for recommendations for improvement, the legislature should provide clearer guidance, and when the court gives them the directives, once some sections of the law are declared unconstitutional, the court wants that amendment or reform to the law be done, but we have seen that this does not always happen. So I see my time is up. So maybe to just comment on sentencing. So for this, largely the court applies the sentencing policy guidelines, and the proposal here would be to put this in statute so that there is a more uniform application of it. For prison overcrowding, that is a problem as well in Kenya. So the proposals that have been made should also be implemented there. Yes, so let me stop here in the interest of time. I thank you so much for the opportunity.
Another round of applause. I apologize in advance about the time. I'm going to be quite strict about it because we're trying to redeem time here, but we appreciate the richness of the presentations thus far. Our next presenter is the Honorable Justice Tadeo Asimwe. The Ugandans can clap if they have hands there. Honorable Justice Asimwe is a distinguished legal professional from Bachelor of Laws, honors from Makerere University, Kampala, and a postgraduate diploma in legal practice from the Law Development Center. He also earned a master's in business administration from ESAMI, the Eastern Southern Africa Management Institute. Throughout his career, Honorable Asimwe has held various significant positions, including serving as the project advocate for the Legal Aid Project of the Uganda Law Society, a state attorney in the DPP's office, and a resident state attorney in multiple jurisdictions in Uganda. His extensive experience in the legal field includes roles such as Associate Partner at the Law Development Center, Principal Legal Officer at the Judicial Service Commission, and Deputy Registrar at the High Court of Uganda. From 2014 to 2018, Honorable Asimwe served as the Registrar at the Inspectorate of Courts and the Court of Appeal. He then took on the role of Resident Judge for the Mbale High Court Circuit and later the Senior Resident Judge for the Mbarara High Court Circuit. Currently, he is the Deputy Head of the Land Division, having previously served as the Deputy Head of the Criminal Division. Honorable Asimwe has also demonstrated leadership in various capacities, including as the Guild Speaker at the Law Development Center, the President of the Uganda Judicial Officers Association, and Chairperson of the National Community Service Committee. His contributions to the legal profession and his commitment to justice have been significant and impactful. My Lord Justice Tadeo, you're welcome. Please welcome him.
Thank you, my Lord Justice Olive, my Lords, the Honorable, all the judicial officers in this room. 10 minutes is very little, as you all know. And my Lord here, Olive, knows that when a paper is presented by a distinguished retired Chief Justice, it is a cocktail of issues. And therefore, I'll be very brief so that we allow the audience to discuss. Thank you, my Lord, for emphasizing that we have the mandate and the role promote and protect the rights as enshrined in our various constitutions. And I agree with you entirely that we are being called upon not to abdicate our duties, and that is very, very key. And therefore, we should work as leaders. We should take the lead. Those are very, very critical. If I got you right, he called upon us to be in charge. We are judicial officers. Are we in charge of our courts? When things fail to move, do we throw our hands in the air? And the message is no, that should never happen. He has called upon us to be the leaders of the teams. Administration of justice is a chain, I agree entirely. And it is a process right from arrest up to sentencing. And therefore there are a number of innovations which are going on throughout our judiciaries. And therefore we're here to share the positives for our different judiciaries to replicate. The issue of case backlog is alive and kicking in Uganda. Prison congestion, there's no debate, and therefore the call for alternative ways of sentencing is very, very, very critical. What are the innovations Uganda is doing in these areas? In the fight against case backlog, first of all, Uganda Judiciary has established the Case Backlog Committee, which is alive and kicking, headed by the Honorable the Deputy Justice seated here, and every quarter we review and see performance. And in that regard, as we speak now in Uganda, we have fully embraced the ADR system, again headed by our current Honorable DCJ seated here. So we have ignited the engine by recruiting retired judicial officers, advocates, and other professionals attached to various divisions. to do ADR, mediate, because we have realized we can never finish the cases through the litigation. It is not possible. That's the account. And I thank the retired CJ who said the area of ADR, we have noticed that the bar plays a very key role, and because they advise, so once they resist the processes, you are likely not to achieve a lot. Since we're sharing countries' perspectives, in Uganda today, we have embarked on the system of training the bars well, in addition to training the mediators. These mediators have been now accredited, and they sit in our courts. So because we saw the resistance of the bar, we are now bringing on board training of the lawyers so that we run as a team, as it has been suggested here today. Small claim, just like Kenya, it is alive and running in Uganda. Every magistrate now deals with those matters, and we do not allow advocates to participate. Some lawyers have challenged the processes. It is giving us judicial officers determine those matters in a day. Some are seated here in this audience. One day, small claim case is done. You issued a check, it bounced. How much money? 1 million. The check is tendered in court. The magistrate issues the order for you to pay the money. Case closed. Very fast speed. Plea bargain is another intervention the Uganda judiciary is doing. And there are sessions running throughout the country where prisoners give us a list, we go and deal with those cases. And it is doing wonders. It's saving government money, and the results are very positive. I will encourage all our judiciaries to embrace plea bargain. It is a nice thing.